there's the idea that the combatant status review tribunals, in the words of Senator Lindsey Graham, are GC3 Article 5 tribunals on steroids, that it's more than what detainees are entitled to. But the fact is that Article 5 tribunals under the Third Convention determine whether or not a person is a POW, or if not a POW, a civilian under the Fourth Convention. And CSRTs do nothing of the sort. What CSRTs do is determine whether a person is a, quote, enemy combatant, which is a newly created category. So once again, I think the lesson to be learned from that is that if Congress had paid better attention to the requisites of the Geneva Conventions, then we wouldn't be in the fix that we are today. And maybe Congress would have paid better attention had the administration paid better attention in the first place. But since the administration didn't, for whatever reasons, it would have been incumbent on Congress to get it right. And if Congress doesn't get it right, then the individuals who are affected, because we have international obligations to provide remedies for individuals whose rights under international law are violated, that means that the courts are the place of last resort and completely appropriate to handle those situations.
And that sort of captures the idea of the replacement theory of constitutional structure. Yeah. Ambassador, you want to respond to that and we'll open it up?
Yeah, just very quickly. I don't think it's that simple. And in fact, I think it's actually a little more complex. I don't think it's a matter of POW versus civilian, because, you know, as we don't have time to get into the whole legal analysis of what makes someone a prisoner of war, but there is this other category where you have these people who are actually combatants. They don't have the legal right to engage in war, but they are combatants. They're not civilians. They're there waging war. So that is a third or a middle category, and what we did when we looked at this, and this is exactly what we briefed to Congress, is we said we have this group of unlawful combatants, and how do you deal with them? They don't merit or warrant POW status, which is designed to basically protect the lawful soldier that's engaged in their lawful duty and responsibility. They're not civilians because they're actually out there waging war. So what do you do with this middle group? But I just wanted to put that out there.
Can I respond to that?
That's what that's about.
That gets to an old question about which I think Professor Jones was talking about before, whether there is a fissure in the conventions that leaves some category uncovered. I would just say that the ambassador's view is not the majority one. But why don't we open it up to questions? Yeah, of course, by all means, absolutely.
The Fourth Geneva Convention, which is applicable to civilians, makes no distinction between civilians who remain peaceably in their homes and go about their lives and their jobs, and those who participate in hostilities. In other words, in fact, the Fourth Geneva Convention recognizes that there are civilians who, by virtue of their conduct, could be interned, could be detained, could even be charged with crimes. So I think the idea, the suggestion that a person who engages in hostilities and is not a member of the armed forces somehow occupies a netherworld third category is not correct under the conventions themselves. Those individuals are still civilians, and they can be prosecuted, they can be detained, but they do not lose their civilian status on account of their participation in hostilities.
All right, just a quick response. The one thing that we need to remember, first of all, I'm not espousing a particular position. I'm stating what I believe to be some issues and facts. But the one confusion that is globally out there is that the Geneva Convention is the exclusive governing body of law in the times of war, where it is not. There are other bodies of law, customary law, laws of wars that have been there, and you have to read them in their entirety.
Shall we open it up? Philippe will come back to you, but Professor Fletcher, and okay, let's start with you, Professor.
Okay. So just two comments. First, I always find it very interesting having these discussions about responsibility, and no one ever thinks, hey, maybe we're responsible as, we're always pointing the finger at the Congress executives, some of the courts, but academics in this particular situation bear a very serious responsibility that we did not begin criticizing the policies of the government in print. We did did not form a consensus of any sort. There was no teaching. There was no combined forces. It was extremely difficult to find people in 2002 who would even talk about these questions. So I think that there's a large responsibility on academia for just standing by and allowing these things to occur and going on with business as usual, teaching our usual courses and observing what the other people are doing without formulating a very clear consensus of our own. On the question of middle categories, because I think what the problem here is that there are two different ways of looking at participation in armed conflict. One is a status question and the other is an action question. So there are, if you look at the provision under the 14th Geneva Convention 51.3, when someone is taking active part in hostilities and then becomes, according to this Barak, becomes subject to targeted assassination, the question is whether, as a result of participating, taking an active part in the hostilities, you are just engaged in conduct that is threatening to the other side, and your conduct may be interfered with so long as it is threatening, or whether your status has changed and you have now become a quasi-combatant. Now, this makes a tremendous difference with regard to targeting people at home at night, because if their conduct is not actually threatening at that very moment, then what's the justification for targeting them when they are in a quiescent mode? This, and I think the whole nature of the law of war is that it permits targeting when people are not actually threats. It permits targeting by virtue of a status, that is, being a member of an organization that as a whole presents a threat. And it's never been clear to me whether either of these categories, unlawful combatant under Kieran or the 51.3 category of a person taking active part, is an exception just based on conduct, or whether it is a clear change of status that triggers a separate body of law.